thank you to Judicial Title for hosting us today. I would also like to thank everyone in attendance for joining and spending their lunch break with us. If I could see you, I would probably say I probably know a lot of familiar faces. So it's good to see a black screen in front of me, but I hope you enjoy your next hour or so watching Ron and I talk about what we love to do. My name is Michael Bobick. I'm here with my colleague, Ron Mandel. We are the heads of the Loft and Zoning Use practice at BBG. Today, we're going to talk to you about some of the hot topics in both zoning and loft law. With that said, Ron, take it away.
Thanks, Mike. Hi, everyone. So Mike and I thought it best to begin our conversation with the basics concerning New York City zoning law and loft law. One of the common misconceptions is that zoning and loft law are both governed by the same set of regulations. However, although there is overlap in terms of their role as land use controls in the city, and there is overlap concerning enforcement and their applicability to certain buildings, zoning and loft laws are governed by independent regulations. With respect to zoning, the first question really is how we got here. So we thought we could take you from the beginning and give you some background. In 1916, New York City adopted the nation's first comprehensive set of zoning controls. It was known at the time as the Building Zone Resolution. As I'm sure you can imagine, since the first zoning laws were put in place in New York City, now over a century ago, the zoning text has evolved. It's responded to different political, economic, social, cultural motivations and pressures. Zoning is always in flux, which is what I love about it, and we'll touch more upon some recent interesting changes later in our presentation. Well, the adoption of the Building Zone Resolution in 1916 was in response to the uproar in communities concerning New York's regulation of land development, including one of the first controversial large developments in the city, which was the 42-story Equitable building developed on Lower Broadway at 120 Broadway in Manhattan. The Equitable building threw a large shadow across Broadway, and neighboring property owners complained that the large building deprived their lots of access to light and air. Ironically, over 100 years later, the city's Department of City Planning moved into that building, the building that kind of started it all in 1916. At that time, there was a growing concern about the need to control the location of different uses around the city, particularly those uses that were considered incompatible with surrounding neighborhoods. So for example, no one wanted to have a slaughterhouse or a tannery, if you know what a tannery even is, but no one wanted those kind of noxious uses to be located either in or next door to a residential area. So ahead of its time in 1916, the text established controls on the bulk of new buildings involving the regulation of their height and also their setbacks. And to help separate incompatible uses, there was the establishment of 3 separate districts. There was the residential district, where there were no businesses or industries permitted. There were business districts, where specific businesses and industries were permitted to be located. And third, there was the unrestricted districts, which permitted a broad spectrum of residential, business, and industrial uses. Fast forward a little bit later, in 1920, in an important court decision, Lincoln Trust Company v. Williams, the New York Court of Appeals held that the city's comprehensive zoning ordinance was a proper exercise of the city's police power. In the Lincoln case, the plaintiff was a seller of real property in New York City, and the suit to compel defendant purchaser to specifically perform the contract for the purchase and sale of plaintiff's property. The defendant sought the return of its contract deposit on the ground that the sales contract provided that the property was to be conveyed free from all encumbrances except certain ones specified, and that it was in fact subject to the encumbrance by virtue of the city's zoning resolution. In the Lincoln case, the court noted that there was no evidence to show that the city's zoning ordinance affected in any way the value of the property contracted to be conveyed, or that by reason of the ordinance, if the defendant took title, that it would sustain any damages. This was a huge windfall for proponents of the zoning regulation. By 1926, all but 5 of the 48 states adopted zoning enabling acts, and those enabling acts served as a foundation for comprehensive zoning ordinances in municipalities throughout the US. In that same year, in 1926, the US Supreme Court established the constitutionality of comprehensive zoning in its seminal decision in Village of Euclid, Ohio versus Ambler Realty. Now let's quickly fast forward to December 15th, 1961. New York City then undertook an extensive overhaul of its zoning regulations, replacing the 1916 Building Zone Resolution with what's known today as the New York City Zoning Resolution. The city zoning resolution at the time contained nearly 900 pages spread through 3 volumes, and it radically altered the way in which New York City now controlled the use and development of its land. Interestingly, there was a couple of new concepts introduced in 1961. The new text introduced the concept of floor area ratio, FAR, as a means of limiting the allowable densities in certain areas. For those of you who are not familiar with FAR, what it simply means is that it's a factor that you multiply the lot area by to determine how much floor area can be built on a zoning lot. So the concept of FAR, floor area ratio, was introduced in 1961. The 1961 zoning text also introduced a host of other concepts which strictly matched varying bulk regulations to an expanded range of zoning districts that were newly created. The first 2 volumes of the text contain the zoning text. Today, it's grown substantially since 1961, but it contains 14 articles establishing the city's zoning districts, and also it sets forth the regulations applicable to each of those districts. The third volume of the zoning text includes zoning maps. Today, there are about 126 zoning maps that cover the entire city of New York. The zoning resolution in 61 established 3 basic zoning districts, not very different, but a lot more detailed than the 1916 text. The 3 districts were residential, commercial, and manufacturing, which are denominated in the text and also by the maps by R for residential, C commercial, and M for manufacturing. In turn, the basic districts, those R, C, and M districts, are divided to reflect varying densities and uses that are permitted within the respective districts. And as you can imagine, over time, those divisions got even more detailed and even more subdivided, depending on the location of the city and the types of uses and bulks that would be permitted. In some cases, there also exists special use districts, which are layered on top of either the residential, commercial, or manufacturing districts. So for example, I'll touch upon it later, you could have a manufacturing and residential district in Lower Manhattan, and on top of that, there's a special district which provides for additional regulations. When we think of loft buildings in the city, particularly in Soho and NoHo, you may have heard of certain designations, for example, those called M15As and M15B zoning districts. Those districts were actually under scrutiny in the recent public meetings, if you've been following it, including the meetings concerning the Soho NoHo neighborhood plan, which was adopted by the City Council on December 15th, 2021. Those unique districts, M15As and M15Bs, emerged following efforts of local artists, residents, and politicians through the 60s and 70s to try to legalize loft housing for artists, either who were living in those areas or were trying to move into those areas or work in those areas. As I mentioned earlier, zoning regulations respond to different pressures, sometimes political, sometimes economic, and/or cultural, potentially. Well, in 1960 to 1961, there are a number of fires that broke out in Soho, which resulted in several deaths. Those incidents resulted in routine inspections by the city's Department of Buildings and also by the fire department of the aging buildings in Lower Manhattan. During those inspections, the city discovered artists living illegally in industrial lofts. As a result, the city began to evict those illegal residents from those loft buildings that they thought were dangerous. In response to the evictions, the Soho residents created an association. At the time, it was called the Artists Tenants Association, which met for the first time around April 1961. The association developed something called the Artists in Residence, an AIR program, which many of you may have heard of, which was kind of revamped in the last several decades. That AIR program was a totally novel concept with respect to trying to justify and legalize artists living in lofts. In August 1961, an agreement was reached between the city and the association in which all eligible artists who sent a letter to the Commissioner of Buildings and who placed a sign outside their apartment could be allowed to live in commercially zoned buildings, so long as those buildings had two means of egress and there was no excessive fire hazards. In addition, one of the limitations was that only 2 loft residences were allowed per building. So that was in 1961. Well, that agreement between the mayor and the association remained unofficial and loosely enforced for the next 10 years. Then in 1971, the city adopted a zoning amendment creating 2 new districts, the M15A and the M15B zoning districts. They also created a new zoning use group category called Use Group 17D, which actually was a manufacturing designation under the zoning resolution. The term for artists living in those non-residential zones was given the name Joint Live Work Quarters for Artists, or also known as JLWQA. Under this designation, one occupant of the unit was required to be certified as an artist by the city's Department of Cultural Affairs. And interestingly, a certified artist was required to be a manufacturer of art, such as a painter or sculptor or even a poet. But a singer or actor would not qualify as a certified artist under the cultural affairs requirements. Mike, why don't you walk us through now kind of the transition to how loft law became established?
Thanks, Ron. So the loft law, how did we get here? Everyone's favorite topic. In the 1960s and 1970s, landlords of these commercial and manufacturing buildings were coping with the loss of New York City's manufacturing industry and the loss of rental income by renting their empty commercial and/or warehouse buildings to tenants and/or artists seeking inexpensive places to live and work. These tenants and artists would rent large, open, empty spaces and spend thousands of their own dollars to convert these places into live workspaces with kitchens, bathrooms, bedrooms, and the services necessary to live, such as water, gas, electricity. However, these live workspaces were not legal under the law. Such residential use was contrary to the underlying zoning districts, which were restricted to manufacturing use. Furthermore, these conversions were done without compliance with building codes and laws and without compliance with the multiple dwelling law. Towards this end of the 70s, neighborhoods like Soho, NoHo, and Chelsea were a hot commodity. The demand for these types of live-work spaces created the tension that ultimately led to the passage of the loft law. With these areas becoming more desirable, owners began to increase the rents, while tenants in turn would threaten rent strikes. This led to an increase in the number of eviction proceedings. As a means to a compromise, the New York State Legislature enacted the loft law on June 21, 1982. The loft law's enactment was designed to address problems that had been created by this widespread conversion of commercial and manufacturing buildings to residential use, without complying with all of the building codes and laws and the minimum housing maintenance standards. The loft law provided a framework for legitimizing these residential occupancies of converted loft spaces and clarifying the rights and obligations of residential loft tenants and their landlords. The loft law created a system that requires owners of loft buildings, referred to commonly as interim multiple dwellings. You're not a multiple dwelling, but you're in the interim stage once you are registered with the loft board, to legalize these IMDs for residential use and provide basic housing maintenance services, while also providing tenants with an opportunity to assist in paying for the cost of legalization. The loft law also provided a means for owners to collect and increase rent, while tenants would obtain rent stabilization protection. One important fact to point out, with the passage of the loft law in 1982, it allowed non-artists to occupy these live workspaces without the need to obtain an artist certification from the Department of Cultural Affairs. Although the criteria to obtain coverage as an IMD has changed since the first enactment of the loft law in 1982, tenants applying for a loft coverage must still be able to demonstrate that the building was the residence or home of 3 or more families living independently from one another during the following window periods. There are April 1st, 1980 through December 1st, 1981. That's the original loft law. You have April 1st, 1980 to May 1st, 1987, which was the law of 281-4 from 1987. You have the 2008 to 2009 version, January 1st, 2008 to December 31st, 2009, which is the MDL 281-5 version of the law. And then most recently, the January 1st, 2015 to December 31st, 2016, which is MDL 281-6. So again, an applicant would have to prove that there were 3 or more families living independently of one another during one of these window periods. Now, prior to the passage of the latest amendment to the Loft Law, i.e. the June 21st, 2019 amendment, in addition to proving this residential use during the window periods, among other things, applicants applying for coverage had to demonstrate that the unit was not located in a basement or cellar, and had to prove that the unit had at least one window opening onto a street or a lawful yard or court, as defined by the zoning resolution. On June 25th, 2019, among other things, the New York State Legislature removed the basement requirement and the window requirement. The idea was to make it easier and to qualify more units for coverage. The idea was also to force the window issue rather than an issue for coverage. It's more of an issue for legalization. Now, to some of the basic rights and obligations of the Loft Law are: it legitimizes the residential use in manufacturing commercial buildings, which otherwise would have only been used by manufacturing or commercial tenants. It requires owners to legalize IMD buildings, pursue and obtain a multiple dwelling law 301 C of O, and make them safe for human habitation. It provides a means for owners to collect rent from occupants, even though the building does not have a residential C of O. It gives residential occupants entitled to loft protection the right to continued occupancy, provided the unit is their primary residence. It regulates the rent while simultaneously allowing owners 3 separate rent increases upon achieving certain code compliance milestones. Gives residential occupants entitled to loft protection the right to sell these improvements, to sell the improvements they made to their own units, as well as any loft rights they may have back to the owner pursuant to MDL 286-6 and 286-12. And finally, it provides for rent stabilization protection upon an owner obtaining a residential C of O for the building. Now, a little Loft Law versus zoning, which I always like to rub in, is, not many people know or do not realize that pursuant to the original Loft Law, IMDs were limited to buildings located in geographical areas in which the zoning permitted residential use as of right. So this obviously limited the number of units that could qualify for under Loft Law. Well, in 1987, the law was amended to include a new subdivision, Subdivision 4, which got rid of the residential zoning requirement as of right. Today, any unit in any district could be a loft unit as long as the residential requirements are met. So a little back and forth with zoning. I say Loft Law will always trump zoning. And with that, I'll send it back to Ron for some hot topics in zoning.
Thank you, Mike, for walking us through the basics of Loft Law. Before I begin discussing some zoning hot topics, I also wanted to clarify that notwithstanding M15A and M15B zoning districts, there are situations and unique districts in the city where new residents were and continue to be able to move into manufacturing and commercial zoning districts, either through Loft Law designation, as Mike pointed out, or through discretionary application processes, including special permits, variances, and other zoning changes. And I'm glad to discuss those mechanisms for conversion after this presentation. As Mike explained, in 1982, the state's Loft Law was enacted, which even more broadly legalized loft living and loft conversion for people beyond artists. Around that same time in the 1980s, retail use began to flourish in the Soho, NoHo area. And as you can imagine, many artists they started selling their spacious lofts to non-artists. Zoning noncompliance in Soho, NoHo increased over the years until it reached a critical mass. Many researchers believe that noncompliance estimated to be at over 80% noncompliant. Then in December 2021, one of our hot topics took effect. the City Council adopted two major pieces of legislation. Collectively, that legislation is known as the Soho-NoHo Neighborhood Plan. These radical steps that the council took updated the zoning in the Soho-NoHo area and established a hefty conversion fund. And it also required the inclusion of low to moderate income housing for any residential developments and conversions of buildings in that area. So I mentioned the Soho-NoHo Neighborhood Plan. Well, generally it consisted of two things: a zoning map change and a zoning text change to create a new special use district known as the Soho-NoHo Mixed Use District. As a result, nearly all the M15A and M15B zoning districts were replaced with mixed use districts, which were rezoned M15 coupled with a residential zoning district classification, ranging from R7D to R9A, R7X to R10. I mentioned before how there were different designations. So, R1s, R2s, R3s. What the city did was they basically created M15/R7Ds or R710s, for example. And each of those designations permits a different bulk requirement, potentially different use requirements within the special Soho-NoHo area. These changes also authorize properties in the area to be developed with greater floor area than they were before, and they introduce more types of community facility uses and residences as of right. The trade-off of the rezoning to allow for residential use, there's always a trade-off, was the designation of the special district as a mandatory inclusionary housing area. That means, as a general rule, that developments that introduce residential floor area are now required to provide affordable housing in accordance with section 23-154 of the zoning text, which mandates that at least 25% of the residential floor area be affordable floor area within the building. There are exceptions. Importantly, with respect to the affordable units, the qualification by prospective residents for such affordable units is based on income limitations as well. The zoning resolution does provide for a mechanism to allow developers to contribute to an affordable housing fund instead of providing affordable units within the building. The way they can do that is by applying and obtaining from the city's Board of Standards and Appeals a special permit. And they're required to demonstrate specific practical difficulties in order to be eligible for that special permit. In another hot change, conversions to JLWQA units will no longer be permitted within the special district, since now, as I mentioned, residential uses are permitted. However, a special process does have to be followed. And we're starting to see that these applications are starting to be put together by practitioners. An application needs to be filed with the Department of City Planning to obtain a certification by the chairperson of the City Planning Commission. And the certification requires in part a contribution to the Soho-NoHo Arts Fund for each square foot of JLWQA floor area being converted to residential use. The text now provides that the cost for that conversion, the contribution to the fund is based upon a figure of $100 per square foot. And the text provides that that number will fluctuate annually, potentially based upon the CPI in effect during that year. In addition, interestingly, the New York City Council passed an amendment to the city's administrative code that increased penalties for violations concerning those JLWQA units to $15,000 for the first offense and $25,000 for each subsequent offense, plus potentially a separate monthly penalty for each month that the violation is not corrected. That violation being occupancy of a unit, not by a certified artist. Thankfully, the law never went into effect because it was vetoed by Mayor Adams. In addition, to protect long-term residents, the state's legislature adopted a new law to protect existing tenants of those JLWQA units. In July 2022, this past summer, Governor Hochul signed into law a bill that modified Article 7B of the state's multiple dwelling law. The law changed the definition of artist in Section 276 of the MDL. Effectively, what it did was that it amended the MDL to protect permanent occupants that lived in JLWQA units, so long as they lived there since at least December 15th, 2021, which was the date of the rezoning in Soho-NoHo. Any of these permanent occupants are now treated as artists, whether or not they were previously certified by the Department of Cultural Affairs of the City of New York. It's important to note that it must be the unit's occupant that's been living in the unit since December 15th, 2021. The law does not certify that the unit's owner is an artist, merely the long-term occupant of that unit. In addition, the law does not protect future owners or tenants of those JLWQA units. Future tenants need to either be certified as artists by the Department of Cultural Affairs, and there's a process for that, or the JLWQA unit must go through a certification process of being converted to a residential apartment. Again, an application has to be filed with the Department of City Planning, and has to go through that review process and get approved. And obviously, at the end of the day, once you get the certification from City Planning, the building's CO, certificate of occupancy, has to also be amended to reflect that residential use. Another interesting recent zoning change involving loft-type buildings relates to the retention of non-residential uses. For those buildings in the Soho-NoHo area that have at least 60,000 square feet of floor area, and in which there's at least 20% of non-residential floor area, conversions to residential are only allowed if they obtain a certification by the chair of the City Planning Commission. That's also an application process similar to the JLWQA conversions. In this case, the certification requires that either the proposed building contain at least the amount of non-residential floor area that was maintained, or that the building will be converted to residences that are exclusively income-restricted housing units. Before I turn over the mic to Michael, I wanted to also mention another hot topic that has been discussed recently in the media, and Richard touched upon it in his introduction. This past Monday, New York City Mayor Adams unveiled recommendations from a city-led task force to facilitate the conversion of underused office space into new housing. Again, we're anticipating that these potential changes are going to affect us citywide, but we're going to see a lot of these changes being made in certain parts of Manhattan where there's previously office spaces, whether it's Midtown or downtown. The New York City Office Adaptive Reuse Study, which is what was presented on Monday, presents 11 recommendations that would make changes to state laws and potentially city zoning requirements, an effort to make conversion regulations more flexible so that the private industry can more easily take these non-residential buildings and make them into residential buildings. The mayor noted that these office conversions could potentially create as many as 20,000 homes within the next 10 years. And I just wanted to touch upon some of those recommendations that I thought were very interesting, and they obviously require a lot more fleshing out by the city and the state, but I think it's a good start. One of the recommendations allows the application of zoning conversion regulations, which now actually apply to buildings constructed through 1961. There are a set of regulations in the current zoning text that allow for more flexibility in zoning application to allow for conversions in loft buildings. But again, that only applies to buildings that were constructed through 1961. What the mayor is suggesting in the study is that we apply those regulations to office buildings constructed through 1990. Another recommendation was to expand flexible conversion regulations to all high-intensity office districts. That would include downtown Flushing, as well as the Bronx hub. The report also cites finding opportunities to allow housing in the high-density part of Midtown Manhattan, which currently prohibits residential development. The report discusses pursuing a tax incentive program to support the production of affordable and mixed income housing. And lastly, I thought was interesting was that the report cites to creating a property tax abatement program to incentivize retrofitting office space for childcare centers. And I think the idea behind that is to make sure that there are services being provided in these future residential neighborhoods. There's obviously a lot more that has to be done. The city and both the state have to adopt regulations or amend regulations to allow for this flexibility. But I think, where market conditions are, hopefully this will move a lot quicker in the near future.
All right, thanks, Ron. Thanks for those hot topics in zoning. I'm going to talk about a few hot topics in loft law. Today's loft law is a hot topic all on its own. Here are a few that I think are important to talk about today. First one being sale of rights pursuant to the Multiple Dwelling Law 286-12. Briefly, an owner can purchase an IMD tenant and protected occupant's rights under the Loft Law pursuant to MDL 286-12. The tenant is basically selling his or her loft rights under the Loft Law to the owner for negotiated consideration. The term negotiated consideration is itself a hot topic. For many years, the Loft would review buyout agreements for completeness sake, that is to confirm that all documents were signed, filed, that the sales record form was signed, filed, whether the surrender agreement, if there was one, or an agreement on its own, was filed. In 2017, that all changed. In the matter of 99 Sutton, the Loft Board had rejected a considerable amount of buyout sale of rights agreements for what they had deemed inadequate consideration. There, the consideration ranged from $0, $1, and $10. The Loft Board had ruled that this was inadequate consideration to buy out the rent stabilization protection that comes with Loft Law protection. Now, based on this ruling and others that followed, sales agreements are very closely scrutinized, both by the Loft Board, who will review, make sure that there was consideration exchanged, and by tenants who have the right to challenge prior agreements, regardless of the amount of time between the sale and the time they file an application to challenge. So this is a very big topic in the Loft world. Another topic related to sales of rights is the decision from the Court of Appeals back in February of 2022, Aurora Associates LLC versus Locatelli. Again, another sale of rights topic. But before we get into that, I just want to briefly talk about the effect of a sale of rights and the effect it has on rights and obligations of an owner and a tenant. Now, upon the purchase of an occupant's, the protected occupant's loft rights pursuant to MDL 286-12, the owner may convert the unit back to commercial use, relieving the owner of all lawful obligations, including the requirement to legalize and the requirement to pay $500 for as the registration fee every year. Now, in order to convert a unit back to commercial use, the owner will first have to remove any residential fixtures, including a bathtub, shower, or possibly a stove. If there happens to be gas, the Loft Board may ask that the owner properly cap the gas line. Upon removing these items, the owner will then have to request an inspection by the Loft Board. The Loft Board inspector will go out, confirm whether it's vacant or being used commercially. Upon acceptance, the Loft Board will designate the unit as by C. Buy out plus commercial use by C. If the unit were to remain residential, an owner can, after sale of rights, an owner can keep the unit residential. The unit would be classified as a by R, buyout, residential. Now, if an owner is using or going to continue to use the unit as residential, the owner is subject to all of the Loft Law requirements, including legalization, obtaining a final C of O, except that the unit is no longer subject to rent regulation. Well, that leads us into the Aurora decision. Basically, where a sale of rights occurred for a unit in a building with less than 6 units, a sale of rights would permanently deregulate and destabilize the unit from rent stabilization. Not so for pre-1974 buildings with 6 or more units that could qualify for rent stabilization pursuant to the Emergency Tenant Protection Act of 1974, irrespective of Loft Law coverage. This was the holding of Acevedo versus Piano Building LLC, issued in 2009, which held that a unit subject to a Loft Law sale of rights may still be subject to rent stabilization by virtue of the ETPA, even though the unit was deregulated by a Loft Law sale of rights. Now, in Aurora, we have a unit that was subject to a Loft Law sale of rights. The owner then subsequently rented the unit out for residential use pursuant to market rate lease. After the expiration of that lease term, the tenant, Locatelli, then claimed continued protection under the ETPA by virtue of the building having 6 or more units. The Court of Appeals found that the conversions made legal solely by the Loft Law do not default to rent stabilization under the ETPA. Specifically, and most importantly, the Court of Appeals found that a unit undergoing legalization, i.e. an IMD unit, does not constitute a housing accommodation within the meaning of the rent stabilization law, and as such, is not subject to rent stabilization after a lawful buyout. Therefore, a lawful sale of rights will now destabilize a unit from rent stabilization. Considering that the Housing Stability and Tenant Protection Act of 2019 completely overhauled how a unit could be destabilized, deregulated, this was a big win for property owners. It's probably one of the few benefits the Loft law provides to owner these days, just my opinion. Enforcement. Another hot topic in the Loft Board world is the Loft Board's decision to restart its enforcement division, which prior to mid-2022 had laid dormant for years. Under the Loft Board's authority, pursuant to MDL 282.2, the Loft Board is allowed to issue violations for failure to comply with its rules and issue civil penalties not to exceed $25,000. As some of you may know or may be aware from experience, the Loft Board has been issuing violations pursuant to MDL 282.2 and Title 29 of the Rules of the City of New York, the Loft Board's regulations, Section 2-01.1, for failure to take reasonable and necessary action to legalize. So basically, these violations can range from failure to file monthly legalization reports, which I'll get to in a couple minutes, the failure to file an alteration type 1 application, which is the change of use application filed with the Department of Buildings to change the use from manufacturing or commercial to residential, failure to obtain a permit where the Loft Board has issued a Loft Board certification of the narrative statement process, failure to maintain a permit, i.e. an owner had received Loft Board certification, was able to obtain a permit, and at some point, for various reasons, the permit lapsed. Loft Board has been issuing violations for failure to maintain a permit. Finally, there's also been violations for failure to maintain a TCO, a temporary certificate of occupancy, where the Loft Board issued certification, DOB issued a permit, owner started work, and was able to complete a majority of the work to obtain a temporary C of O. Loft Board, if you haven't maintained your TCO, you could be open to some sort of violation. Now, upon receiving one of these violations, an owner has 35 days to either cure the violation, i.e. do what the Loft Board is asking, or file an answer with the Loft Board, which must include information as to why the notice of violation should be withdrawn or mitigating factors that the owner wishes the Loft Board to consider in connection with any fine. These violations honestly must be taken seriously, otherwise you're going to be paying thousands of dollars for some of the smallest things. Although given an opportunity to cure, there may be issues preventing an owner from curing. Such issues may include the slow pace of other government agencies such as Landmarks, the Mayor's Office for People with Disabilities, the Office of Environmental Remediation, and the Department of Buildings. Other issues that may pop up are access issues. Access issues mean an owner is unable to get into a tenant's unit for various reasons, which requires an owner to file a Loft Board application with the Loft Board to obtain a Loft Board access order. The detriment here is it takes a couple months to get this application filed, another couple months to get through the oath process, and then another couple months for the Loft Board to render a decision, which could put you behind about 8 months if you're lucky. Now, failure to cure within 35 days will trigger a $1,000 per day penalty, which maxes out at $17,500. So if anyone out there has permits and TCOs and that haven't been renewed or haven't been issued, be on the lookout for one of these types of violations. You could be on the hook for $17,000 violation. It is imperative that owners of IMD buildings begin taking the steps necessary to legalize their buildings, including but not limited to hiring professionals, filing timely monthly reports. These monthly reports, although tedious and time-consuming, are an excellent tool to provide the Loft Board with an accurate status update of the legalization project. These reports should be thorough, must include current updates, which would explain any potential issue that you may have, which is preventing the owner from completing the stage of legalization or just completing legalization in general. Not only are these monthly reports important for the Loft Board to understand what is plaguing an owner, but the Loft Board will also look to these reports when reviewing letters of no objection. Letters of no objection are requests to the Loft Board for approval for non-legalization work, such as work in commercial or manufacturing units and work in non-residential IMD units. Another way the Loft Board could penalize an owner for failure to legalize is to deny an owner's loan or request. This could be problematic for a number of reasons, including the impact on the relationship between the owner and a commercial tenant who had leased the space, and who might be the only tenant in the building providing the income that an owner may need to legalize the building. So that kind of sums up my hot topics in loft law, and in total that concludes our formal presentation of hot topics in both zoning and loft law. If you have any questions, feel free to ask away.
Can we give the course code?
Yes, the course code is JLWQA. Make life easy.
Is that easy?
I typed it in the chat as well. So
Thanks, Diana.
Everyone, who didn't jot it down, check in the chat, and the code is there. It's JLWQA. And if you get any of the letters mixed up, I will not give you credit.
We're testing people to see how much they paid attention.
Exactly. Exactly. I do have a few questions. You want me to read them to you, and we can, if they're too entailed, we can get back to them. But
yeah, absolutely.
Sure.
Is there a contact?
Don't make them too hard, though.
I'll try. Is there a contact at the New York City DOB or the Board of Standard Appeals that a practitioner could communicate with to answer questions or concerns when they appear in a CO search?
If it was that easy, you wouldn't need us. So conceptually, it should be that easy, though. So the Board of Standard and Appeals is not the agency that would likely provide that information, but DOB, Department of Buildings, would be. It's obviously easier said than done to try to find someone to ask the question. I know that the borough offices, each borough has their own borough office, one in each of the 5 boroughs, and they have Tuesday evenings, at least it used to be Tuesday evenings throughout all the boroughs, like an open forum for the public to go in and ask questions. Homeowners, tenants could go in and ask questions. I think it was from 4 to 7. But if that's a route that someone wants to take, you should just contact the borough office and confirm that someone will actually be there Tuesday afternoons to field those questions.
Okay. Is there anywhere to get a copy of the proposed study by the mayor for the office conversion?
Sure. We can circulate that after the presentation. Not a problem.
Okay, great. This is a little specific, but I'll ask it anyway. I think you sort of answered it, but is there a zoning proposal that will affect the Midtown West area, 56th Street south towards Times Square and west of 8th Avenue?
56th. So there's nothing that city planning has posted in terms of any studies that they're undertaking in that area, any public studies. There is, if we were asked that question, they may be thinking about the Penn Station Civic and Land Use Project. That's not as high as 56th Street, but that is something that's a state project that is currently in the pipeline. It's still not moving as quickly as I think the state was hoping it would move, but that's further south on the west side of Manhattan.
Okay. How would you advise a non-artist purchaser of a Soho Air apartment who has been told about the regulations but insists on buying anyway?
Sure. So I guess I could address the zoning issue that comes up with that. So we're not surprised. I'm not surprised to hear that question. In the last several decades, there's been, the city's been very lax in enforcing air requirements. Some condo and co-op buildings are stricter than others. There was a time in which, this was an industry back in the day there were attorneys who put together packages to try to legitimize purchasers who were not artists moving into these buildings. There was a wave of waiver letters that co-ops and condos were asking for. In other words, condos and co-ops were saying, hey, you want to move in, fine. But if you get caught, we want you to indemnify the co-op and the condo board. That's potentially one way to, protect the boards. Obviously, less reps from the seller is better. But again, we don't believe that everyone's going to file certification applications with city planning. Our office is starting to prepare those applications already on behalf of owners and future owners of those units. But I'm sure that there will be many units that are not converted. And potentially those units could be subject to enforcement activity. And if it's a condo or a co-op, it's possible that the board could be hit with violation. And so I would suggest that those boards do whatever they can to try to get whatever indemnification they can from those future occupants.
Okay. Have you represented any applications for residential conversion? How is the $100 per square foot charge calculated? Is it usable or gross square footage? And has any client actually paid this fee and for litigation to remove this fee?
Sure. So this is all so new for everyone in the city. As I mentioned before, our office is involved in several applications on behalf of unit owners and also boards, both to investigate but also to file these applications. There has not been any approved certifications yet. In accordance with the new NoHo special district, that contribution amount of $100 per square foot is based upon the floor area to be converted from JLWQA to residential use as of December 15th, 2021. So it's not the gross, it's actually the floor area and whatever is involved, in figuring out that calculation.
Okay. Would units in a commercial condo in Soho be subject to the affordable unit restrictions if the sponsor or the individual owner chooses to convert units to residential use?
Mike, I don't sorry, Diana, one more time, please.
Okay. Sure. Would units in a commercial condo be subject to affordable unit restrictions if the sponsor or individual owner chooses to convert to residential?
Potentially, yes. They would be. Again, it depends on the zoning district. It depends on what the regulations are for that particular area, but potentially, yes, they would be subject to affordable requirements. Again, it wouldn't apply to the commercial, but only to the residential. But it definitely is a concern for many boards because, the zoning doesn't discuss ownership. It discusses what the rules are for the zoning lot. And so, it's not as easy as a unit owner kind of going to city planning and applying to convert a unit. They actually have to, it's the board that has to be supportive of that. And for the shareholder and for the board to work together, figure out what makes sense, not just for the shareholder, but for the entire building.
Okay. Is there a list of all the city's zoning districts found anywhere, their designations?
There is. So I mentioned in the presentation, the zoning resolution. It outlines the various, first of all, it identifies what zoning district the specific property is located in. And then once you identify what the zoning district is, you then look through the zoning text to figure out what bulk and use regulations apply in those districts. If the person who's asking that question, has any specific questions about a specific property, happy to address it. You can email me and Mike, and we can give you some more information about your specific property and what that designation is.
Okay. We'll get to one or two more quick questions, and then if you have any further questions, you can shoot me an email and we'll try to get them answered. My loft and 5 others in my 12-story building are rent stabilized for over 5 years. Do we fall under the loft law, or are we permanently residential and not ruled by the loft law?
I guess the question is a little bit loaded. If your building already has a C of O, then the answer is no, you cannot fall under loft law. unless the C of O was not in effect on a certain date and time. If there was a C of O on each effective date of the law, then no, the building would not be subject to Loft law.
All right, in the interest of ending on time, I just wanted to remind everyone the code was, let me tell you again, so I don't mix up the letters, JLWQA. And like I said, if you have any additional questions, you can shoot me an email. I will, before the end of the day, resend everyone the material and the affirmation just in case you don't have it. And Michael and Ron, I want to thank you for a great presentation. It was very timely, especially with all the announcements that just came up. It was very interesting, and I'm sure everyone enjoyed it. We had about 315 people join us today, so we had a really nice audience, and I just wanted to thank you and thank everyone for attending.
Thank you so much.
Thank you. Thank
Take
you,
care,
everyone.
Have a great day, everyone.
Take care.
Happy New Year.
Happy New Year.